Thank you, Mr. Chairman, and thank you for calling this hearing today to discuss the Federal Employees Compensation Act, or FECA. This committee has a primary jurisdiction over workers' compensation laws and has overseen and repeatedly improved FECA since 1949. FECA has been the governing statute providing benefits for federal civilian workers injured or killed on the job since 1916. Some of the key principles that underpin this law include FECA benefits being made available to ensure that workers and their families are no better off or no worse off than if the worker had not been injured. Secondly, all federal civilian workers, regardless of their employer, are eligible for the same benefit. Another underpinning is that all federal civilian workers, same benefit, and that claims for benefits are administered on a no-fault basis. If workers give up their right to bring tort claims for injuries, they need to be fairly compensated in a timely manner, with benefits administered in a non-adversarial way. Consistent with these principles, Mr. Chairman, FECA benefits include compensation for lost wages, medical care, and vocational rehabilitation. FECA ensures that injured workers are not impoverished while their claims are being processed by providing their current income for 45 days following an injury. FECA also provides a cost of living adjustment. Today, we'll be reviewing the administration's legislative proposal. Some parts of it are straightforward. For example, the proposal increases payments for funeral costs, which have not been adjusted since 1949. It provides the Department of Labor permanent authority to access Social Security wage information in order to improve program integrity. However, other aspects of the administration's proposal warrant scrutiny, and that's what we should be talking about today. For example, it cuts wage loss payments for injured workers with dependents and reduces the maximum survivor's death benefit. While these changes may simplify the FECA program, we have to assess the impact on federal workers who have been permanently disabled on the job. The administration also argues that FECA unfairly allows some injured workers to receive more from FECA after they reach a retirement age than if they had earned a retirement on the job. So the Inspector General has called for a redesign, but has not actually specified what that redesign would be. The administration's redesign cuts FECA benefits from permanently disabled workers with dependents from 75% of the average wage to 50% when they reach normal Social Security eligibility age. Perhaps this decision was made on the assumption that individuals leave the workforce and don't pursue employment after age 66. But you know, that's not true anymore, so we have to take that into consideration. Furthermore, this one-size-fits-all approach could result in unfair treatment of injured workers whose wages were low in the first place and possibly violate a core principle of FECA that no one should be economically worse off because of a work-related injury. Before we make an across-the-board change, Mr. Chairman, we'll need to really better understand how the proposed changes will impact the diverse pool of federal employees covered by FECA. So I hope today's hearing will help us begin to answer these questions, and I too look forward to working with you on this.